What if I told you that it isn't just international law, but that it's part of our own law? Tune into Court Center on September 17th to catch the new 30 for 30 special. Is it part of our law?
Hello Waynesburg, and welcome back to Court Center. I'm Scott Stewart.
And I'm Pot Scanvell. We are back on the worldwide leader in courts to bring you another classic court case.
That's right, Pot. We're now moving from the establishment of judicial authority in Marbury versus Madison to the establishment of international law in our court system with the Paquete Habana case.
Paquete Habana established the precedent of customary international law, which is international law established by state practice and consent, which is then followed from a sense of legal obligation.
Our viewers at home may be asking themselves how this case came about. Well, during the Spanish-American War, a Cuban fishing boat called the Paquete Habana was seized by the American ships surrounding Cuba.
The ship was deemed a prize of war by the United States, along with nearly, get this, 9,000 pounds of live fish on board.
The ensuing court case would determine the scope of customary international law and its application in American courts for years to come.
So, is it part of our law?
Well, that's a great question, Pot, and an appropriate title for our brand new Court Center special.
You're exactly right, Scott. Now it's time to sit back, relax, and enjoy the world debut of Is It Part of Our Law?
International law has been around for thousands of years, and its influence has grown quite dramatically around the world in the past 100 or so years. You see this growth in organizations such as the United Nations, World Trade Organization, World Bank, International Monetary Fund, along with numerous foreign treaties and deals. This expansion raises the important question: is international law effective or legitimate? Not only that, but what impact has it had on United States law? There is no other Supreme Court case that answers these questions better than the Paquete Habana. With this short film, I am hoping that you walk away with a better understanding of customary international law and come to your own conclusion on its legitimacy and effectiveness, and whether or not it is applicable to our Constitution.
Throughout the late 1890s, Cuba was a colony of Spain. For years, the Spanish had struggled to quell Cuban uprising for independence. News of their tyrannical misdeeds led the United States to become more sympathetic to the Cuban anti-Spanish movement. In February of 1898, an explosion destroyed the USS Maine just off the coast of Havana. As a result, the U.S. increased its involvement in the Cuban-Spanish conflict. 2 months later, on April 21st, Congress issued a joint resolution calling the military into service. 4 days later, Congress officially declared war against Spain.
So, the day after Congress issued its joint resolution, the Secretary of the Navy, John Davis Long, ordered Naval Admiral William T. Sampson to institute a naval blockade surrounding Cuba. 4 days later, the order was legitimized by Congress's war declaration. Then, the following day, the order was further solidified by President McKinley's direct order.
What makes this entire situation fishy, no pun intended, is that on the 25th, the Paquete Habana was completely unaware of the war declaration and the blockade. And then as it was going about its regular fishing operation, it was on its way back to Havana, and the boat was captured by the US Navy and deemed a prize of war. Then, a few days later, Admiral Sampson wrote a letter to Secretary Long accusing the fishermen of formerly serving the Spanish Navy, and that they should be detained as prisoners of war. Secretary Long agreed.
In 1898, the U.S. federal district courts had original jurisdiction over all prize cases, with appeals going to the Supreme Court. The Spanish-American War produced an increase in the number of these cases. On May 26 that year, the fishermen challenged the capturing of their ship in the United States District Court, Southern District of Florida.
Well, at the district court level, the United States actually won. The fishermen were declared guilty of violating the naval blockade, and the ship was deemed the prize of war. They then ordered that the boat and all of its belongings should be auctioned off to the highest buyer.
However, the fishermen did not buckle to this decision. Just 2 days later, they appealed this ruling to the Supreme Court. In his appeal letter, Juan Pasos, the owner of the Paquete Habana, wished to show that at the time of the capture, his ship was not liable to be captured and seized as a prize of war. Secretary Long and President McKinley did not take this appeal too kindly.
Mr. President, sir, I have a letter for you.
This is a letter from the owner of the Paquete Habana ship. He's filed an appeal to the Supreme Court. What?
Let me see. Uniform practice. Fishing boats exempt from capture. Cuban people free and independent. Can't harm someone we intended to aid? This is preposterous. The district court clearly stated that the Paquete Habana was subject to capture.
On the bright side, Supreme Court precedence on prize cases is in our favor. That blockade was lawfully established, and those Cuban vessels were from a hostile state. That makes them eligible for capture, independent of their freedom.
Precisely. And our blockade was completely in line with the rule of international law. Look, there is no way that the Supreme Court overturns the district court's decision.
After filing their appeal in May of 1898, the fishermen had to wait until November of 1899 to deliver their arguments to the Supreme Court. The appellants were represented by attorney J. Parker Curlin, while the United States was represented by Solicitor General John Richards.
The first argument Curlin made was that the President's declaration stated that the war would be conducted upon principles in harmony with the present views of nations and sanctioned by their recent practice. This meant that both by law and by uniform practice, coast fishing boats were exempt from capture. Not only this, but the naval blockade made no mention of the fact that coastal fishing vessels simply going about their normal fishing business could be captured as prizes of war. The second argument Curlin made was that since Congress had declared the Cuban people free and independent in 1898, they should be granted the rights and privileges of neutrals or allies. In no way were they trying to help the Spanish.
The appellants tried legitimizing their argument by referring to treaties as far back as the 15th century to show that there has been an established law where nations have agreed to not attack or capture civilian fishing vessels during times of war. The historical argument played a huge role in this case.
There's no mention of fishing vessels in this naval blockade. The Paquete Habana is a coastal fishing vessel that in no way aided the enemy war effort. And there is no reason that it should be taken as a prize of war.
Solicitor General Richards began by refuting the argument regarding Cuban neutrality by stating that just because Congress declared them independent does not grant them immunity from violating the blockade.
The Paquete Habana ship was flying under the Spanish flag, while our nation was at war with the Spanish. So of course they would be perceived as enemy ships. Supreme Court decisions dating back to the Civil War have determined that anybody in a hostile state should be treated as an enemy, regardless of where their alliance lies.
Richards then countered with three main points. First, although he admitted that international law is derived from state practice and the authority of writers, he argued that many of these writers went too far and didn't even express the law. Second, American prize law has always followed English rule, which gives great discretion to the executive unless there's a direct rule against it. And third, if there's any exclusion whatsoever, it should apply to small open boats and not ships such as the Paquete Habana. The United States had hoped that these arguments would ultimately influence the Supreme Court in their decision of upholding the seizure of the Paquete Habana.
But their arguments weren't enough. By a vote of 6-3, the Supreme Court sided with the appellants deeming fishing vessels exempt from capture under customary international law. Justice Gray delivered the majority opinion, while Chief Justice Fuller delivered the dissenting opinion.
Justice Gray's opinion refutes John Richards' argument from the get-go. Coast fishing vessels that are simply catching and bringing in fresh fish have been recognized as exempt from the blockade and being captured as prizes of war. The court agreed with the appellant's argument by also citing international practices by several European nations dating back to the 15th century. What Justice Gray is really remembered for, in this case, is when he delivered a very famous line which established impactful precedent in the Supreme Court.
International law is part of our law and must be ascertained and administered by the courts of appropriate jurisdiction. Furthermore, it is an established rule of international law that coastal fishing vessels, with their implements, supplies, cargoes, and crews, unarmed and honestly pursuing their peaceful calling of catching and bringing in of fresh fish, are exempt from capture as prize of war.
In his dissent, Chief Justice Fuller disagreed with the majority, stating that there is nothing in any treaty which grants fishing boats exemption from capture during war. He felt that the majority created this established rule out of thin air as an act of grace rather than a matter of right. He believed that the power of capturing prizes of war falls under Article 2 of the Constitution and is for the President to decide on. He essentially thought that this would have been a better argument for the United States than the one that was made.
Upon the ruling of the case, the Paquete Habana was awarded $4,500 and the highest price for the fish during the blockade, which the United States would pay. The United States appealed and the case was remanded once again, but there is no record of the ultimate amounts paid. Other nations quickly accepted the rule that coastal fishing vessels are exempt from capture under customary international law. However, the rule of protecting coastal fishing vessels soon became irrelevant due to the danger of mines and submarines guarding coastal blockades.
And welcome back to Court Center, everyone. We hope you enjoyed our documentation of that monumental international law case.
Yeah, the Paquete Habana case set an impactful precedent for the United States' involvement regarding international law with not only protecting fishing vessels, but various other foreign affairs.
This all raises the question, what influence has this case had on customary international law? Is it an effective form of law? For answers on these questions, we go to Ron Tonaldi, who sat down with some of the most highly regarded experts on international law.
Thank you, Paul and Scott. Today I'm joined with three of the most renowned international legal scholars and authors, Jack Goldsmith and Eric Posner, authors of The Limits on International Law, and Miss Mary Ellen O'Connell, author of the book that is a direct response to Jack and Eric's book, Power and Purpose of International Law. Thank you three for being here today. So, let's get straight to the point. Is international law legitimate? Let's start with you, Miss O'Connell.
Well, it's very obvious that international law is an essential part of international life. It contains many of the definitions and norms or behaviors that government officials keep in mind when taking action. Individuals and nations alike have been constantly invoking international law as far back as 1648. It essentially permeates our existence, and indeed without it, there would be no diplomatic interactions between nations. To put it plainly, each state is defined by international law.
Mr. Posner and Mr. Goldsmith, what do you have to say about all of that? Is international law legitimate, as Ms. O'Connell says it is?
The two most important parts of our theory are constantly neglected by most international scholars, including Ms. O'Connell. When you don't ignore the two most important actors of our theory, then of course international law does not work on a state-by-state basis.
International law does have its deficits, but its power lies in our belief in its effectiveness, and more times than not, international law persists as the single generally accepted means to solve the world's problems. It's not religion or ideology that we all have in common, but international law.
You're wrong. Plain and simple. The influence of international law resides in our belief in its power. But your claim that it is generally accepted is just not true. And that's why scholars, such as yourself, have to exaggerate its claims of power and significance.
Let's move to the Paquete Habana. What is your take on this decision and its effect on international law?
Now, although prize law has little effect on today, the Paquete Habana is still a crucial decision. It illustrates how international law started as a customary practice and then evolved into an established rule. And it is the first court case that established the existence of customary international law.
Yes, its influence has been crucial. It still doesn't take away the fact that the case itself is riddled with errors that correlate with the mainstream view of customary international law. In his opinion, Justice Gray admits that the fishing vessel exemption was not customary international law at the beginning of the 19th century. Regardless, he uses a selective handful of treaties from the early 15th century to the late 19th century to determine that there is this established rule in international law protecting fishing vessels.
Our theory views that states follow their own interests in all circumstances, so they refrain from seizing ships when there's no advantage, but they seize the ships when there's a balance of advantage.
There's no doubt that this case is the most important international law case in United States law. The court makes it quite clear that even when a president has the power to impose a naval blockade under Article 2 of the Constitution, he must also respect customary international law. This also applies to treaties and other areas of foreign affairs. I think the biggest issue I have with Eric and Jack's critique of the case is their presentation of historic facts. You accuse Justice Gray of being selective with his facts, but rather you're the ones being highly selective with your evidence. There are so many C rules, such as prize, territorial, and diplomacy rules that debunk your model. States have always abided by customary international law rules, regardless of self-interest.
Well, I think that's all the time we've got. Thank you three for joining the show. Back to you guys.
Thank you for that, Ron. Getting that kind of insight from experts such as O'Connell, Goldsmith, and Posner helps provide clarity on the impact of this in the context of international law.
We saw a reemergence of this case recently when the Bush administration asserted that detainees at Guantanamo Bay in Cuba are not protected by customary international law.
Yeah, Scott, the DOJ's Office of Legal Counsel basically said, under Supreme Court precedent, the president's ruling regarding the detention of al-Qaeda prisoners overrides any customary international law. This case illustrates how U.S. courts will give special weight to views of the executive branch when interpreting customary international law.
As we've seen, the Supreme Court's reiteration of international law being a part of our law, in spite of international law's transition from natural law to positivism, reflects a commitment to continuity in the face of legal change.
Well, that's all for tonight. We thank you once again for tuning in to this edition of Court Center. For Scott, I'm Pot. Good night, everybody.